Good afternoon, everyone. My name is Ingrid Culp, and I am an attorney with Frederickson and Byron, and we are going to get going with our webinar this morning. I'd like to also welcome my colleague, Emily Pontius. Emily and I both practice in Frederickson's employment law group. By the wonder of technology, Emily is presenting today from her office in Des Moines, Iowa, and I am here at Frederickson's offices in Minneapolis, Minnesota. So I want to thank our marketing group and our IT group for assisting us today with putting our webinar on. A couple housekeeping items before we get started. If you have questions, we welcome those during our presentation today. If you hover over the bottom of your screen, you will see a chat feature. If you click into that, you can type your question into the chat feature, and it will be printed out here and given to me. And depending on the question, either Emily or myself will be able to respond to it. Based on how things go, we'll either respond to questions kind of in real time, or we may hold the questions, certainly send the questions in as you have them, but we may wait till the end of our presentation to answer the questions. Should the internet audio cut out, please use the dial-in number provided to re-access the audio. So I think we will dive in. So our topic today, mental health issues in the workplace. So pro-business equals pro-employee, and pro-employee equals pro-business. What do we mean by this? Emily and I both firmly believe, and I trust as seasoned HR professionals, you share this view. What's good for business is often good for employees, and what's good for employees is often good for business. As we all know, particularly in recent years, the labor market has been really tight. It is hard to find and retain good employees. So if you have a good employee who has fallen on some hard times with regard to mental health issues, we believe as an employer, anything you can do to support that employee through that issue so that they can maintain a productive, good employee for your business is really going to be a win-win for everybody. Let's talk for a little bit about the impact of mental illness in the workplace. There are some interesting and a bit staggering statistics. 1 in 5 U.S. employees has a psychiatric disability. It is estimated that 85% of employees' mental health conditions are undiagnosed or untreated. This one I think is really interesting and challenging for employers. When they are dealing with employees whose mental health issues are at a crossroads or cross-section with their performance or production at work, but the employee themselves, the employee, him or herself, doesn't even recognize or know that they have a diagnosable condition. 1 in 17 U.S. adults lives with a serious mental illness. 25% of employees with mental illness feel like they are discriminated against or avoided in the workplace. 1/3 of EEOC charges in 2018 alleged disability discrimination. So let's pause on that one for a minute. As you know, the EEOC is our federal anti-discrimination enforcement agency. It's typically the first stop that an employee or former employee makes when they feel they have been wronged in the workplace and want to assert their rights and try to seek some remedies. As you know, the EEOC takes in all kinds of charges based on the long list of protected classes that exist for employees: gender, race, age, religion, retaliation, etc. So the fact that 1/3 of all EEOC charges in 2018 alleged disability discrimination is really telling, for me at least, both in terms of the number of employees in the workplace who identify as having a disability, and then equally alarming, how many feel that they have been discriminated against or failed to receive reasonable accommodation because of their disability. I think it's fair to say that disability discrimination and failure to accommodate is top of mind, both for employees and attorneys who represent employees. And we are seeing more and more of these types of claims come to the forefront. In 2016, the EEOC won $20 million for individuals with disability discrimination claims. So the EEOC dismisses a lot of its charges, but when it finds that an employee has made an allegation that the EEOC thinks has some merit, the EEOC will actively advocate on the employee's behalf in terms of pursuing settlement. And in 2016, as indicated here, the EEOC secured $20 million for individuals with disability discrimination claims to settle those claims. In terms of the workplace impact, I'm sure this will come as no surprise to you. I can't imagine a workplace that hasn't dealt with some employee or more that have mental health issues or other disability issues in the workplace. And how do we see it pop up? Of course, oftentimes we see it pop up with regard to performance. The employee's performance is lacking or unacceptable in some way, shape, or form. Productivity. Oftentimes there's a direct relationship to either attendance or productivity while at work. Engagement, again, how much stamina and interest and gusto do the employees have to give to their work when they're struggling with a mental health issue. Communication can be an area where mental illnesses and the ability to communicate effectively with supervisors and managers and coworkers can really be difficult when an employee is dealing with mental illness. And then sometimes there's a cross-section between a mental illness and a physical ability, and the employee is dealing with both at the same time. The cost to U.S. employers in dealing with employees with mental health issues in the workplace is more than $100 billion and 217 million lost work days from an attendance standpoint. So what can employers do, and what do we as employment lawyers and HR professionals really need to have top of mind? So first, of course, comply with the law, and we'll take a bit of time here today talking about what laws come into play and what it means to comply with those laws. Train supervisors, reduce risk factors, and ultimately promote a healthy workplace. I'm going to present on the comply with the law, and then in a bit here we'll turn it over to Emily to pick up with train supervisors. So let's start with the law. We've got the ADA, the Americans with Disabilities Act, and the Minnesota Human Rights Act, MHRA. And then for our audience members who are in Iowa and have employees in Iowa, we also have the Iowa Human Rights Law that absolutely comes into play for Iowa employers. So the ADA, of course, is a federal law. It applies to all employers in the United States, regardless of what state you work or operate in. It applies to employers with 15 or more employees and says that an employer must not discriminate against an employee with a disability and must reasonably accommodate an employee with a disability, and we'll talk more about what that means in a moment. The Minnesota Human Rights Act applies to employers with one or more employees in Minnesota. So if you are an employer in Minnesota and you have one or more employees, you are subject to the requirements of the Minnesota Human Rights Act. If you have one or more employees, you may not discriminate against an employee based on disability. If you have 15 or more employees and you're a Minnesota employer, then your duty of reasonable accommodation kicks in. Under the Iowa anti-discrimination state law that protects against disability discrimination, it's an Iowa employer with 4 or more employees may not discriminate based on disability and must provide reasonable accommodation to its disabled employees. Now, one thing you might note, if you're an Iowa employer with less than 4 employees or a Minnesota employer with less than 15 employees, you might say to yourself, oh, well, we don't have a duty to reasonably accommodate. We are not subject to the reasonable accommodation provision under federal law, Minnesota law, or Iowa law because we have a small number of employees. While that might be technically true from a legal standpoint, I would caution small employers from taking the approach of turning a blind eye to its reasonable accommodation obligations. One, I think reasonably accommodating our disabled employees so that they can be productive members of the workforce is the right thing to do. And two, if you don't, even though you might not technically have a legal obligation, I think you're going to see those employees and their creative attorneys find a different way of pursuing a legal claim, maybe just in the form of a good old disability discrimination claim, even if it's not a failure to accommodate claim. So I guess my point is, even you small employers, I would recommend follow best practices with regard to reasonable accommodation. So under our disability discrimination and accommodation laws, what do we need to know? Well, first, what employees are covered? All employees are covered regardless of time or tenure of employment. So the duty to not discriminate and to reasonably accommodate a disabled employee applies the minute that you hire an employee, and it in fact applies to applicants as well in the interview process. There's no time of service requirement like we see under the FMLA. And really all that an employee needs to establish to have protection under these laws is that they have a quote-unquote disability. So what does it mean to have a disability? A physical or mental impairment that substantially limits or materially interferes with a major life activity or a major bodily function. I'm going to come back to that bullet point in a moment here. Having a record of such an impairment, so maybe they no longer suffer from this disability, but they have a record of suffering from a disability in the past, or being regarded or recognized as having an impairment. So this last one is somebody who's never had a disability as defined by the law, but their employer believes them to have and treats them accordingly in a discriminatory manner on that basis. So that first bullet, somebody who actually does have a physical or mental impairment, we used to spend a lot of time as employment lawyers fighting with employees and former employees and their attorneys over whether the impairment that they had actually rose to the level of a capital D disability. And we would talk a lot about whether it did or didn't substantially limit or materially interfere with a major life activity. In recent years, due to some amendments and court cases coming out of the disability discrimination laws, we no longer focus so much on whether somebody has a disability such that they're covered by the laws, because almost everybody who can establish that they have a physical or mental impairment is deemed to be disabled. The list of major life activities and the list of major bodily functions, they are very long, they are broad, and they're very inclusive. And it's very easy for an employee and their attorney to establish that whatever the physical or mental impairment is, did in fact or does in fact substantially limit a major life activity or major bodily function. So the takeaway for employers, at least our recommended takeaway, is that you don't take the position that you're not going to reasonably accommodate or help an employee with a medical condition on the basis that you don't think they have a capital D disability. It's really best to just assume, for purposes of the law and your obligations, that if an employee has established that they in fact have a medical condition, mental or physical, that they will qualify for protections under the law. So what does it mean to reasonably accommodate? Reasonable accommodation is a deviation from business as usual that allows a qualified person with a disability to perform the essential functions of his or her job without undue hardship to the employer. So there's a lot here, so let's unpack this. So if you have an employee come to you and say, I am struggling with a mental health issue, I need help to be able to do my work effectively, you as the employer have been put on notice that an employee is seeking an accommodation. And it is your job then to work with the employee and engage in what's called the interactive process. That's a legal term. It's a term that we see arise in the law, where the employer and employee work together to figure out what does the employee need from the standpoint of accommodation to render them able to perform the essential functions of their job, and are the accommodations that are needed something that the employer can reasonably provide, or are they so onerous that they would actually result in an undue hardship to the employer. So let's talk a little bit about common accommodations that we see with regard to accommodating employees with mental illness. So certainly a modified or flexible work schedule is a request we see quite often. A remote work option is a common request, and I'm going to come back to that one in a moment here. A private or quiet workspace, white noise or noise canceling technology, allowing a support animal in the workplace, a change in lighting is another common one that we're seeing more and more. A good old leave of absence, so time away from work so that the employee can seek the medical help that they need to try to be able to come back to the workplace. Separating jobs into discrete tasks, providing instructions in writing, and then again, that last bullet, you'll see uninterrupted time away from work, so essentially a leave of absence. So when we look at this list, you might say to yourself, you know, do we have to provide these things? Are these all automatically a form of reasonable accommodation? And unfortunately, the answer is it depends. What is and isn't a reasonable accommodation, and what would or wouldn't result in undue hardship such that an employer doesn't have to provide certain accommodations, is really case by case. There is rarely a one-size-fits-all because, as you of course know, every business is different, every position is different. So where in one workplace it'd be really easy to provide a private or quiet workspace, that might be impossible for an employee who works on a production floor. So I wish we could give you concrete, discrete answers with regard to absolute musts and need nots, but the law requires employers to engage in a case-by-case analysis, taking into account their business and the employee's job and the impact of the requested accommodation and whether it's reasonable or unreasonable. With regard to remote work option, I want to caution you employers out there, to the extent there are any, who are quick to say no to a request to work remotely. In recent years, the EEOC has told employers that they need to be more open to request to work from home, and that a quick no to that request is not going to be looked upon favorably by the EEOC. Now, certainly there are some jobs that you simply can't work from home. The work has to be performed at the work site. But if you are in an environment where work from home is a possibility, or certainly if you allow other employees to work from home either regularly or from time to time, but you want to say no to your disabled employee, I think that's a risky proposition, because if you allow non-disabled employees to work remotely, but you say no to remote work to a disabled employee, I think as the employer there'd be an uphill battle to explain why it was okay and workable for some employees, but not for others, particularly if they hold similar positions or work in similar work environments. Okay. So as time has passed and these laws have developed, we have gotten some fairly clear answers from the EEOC and the courts on things that are not reasonable, requests from an employee that are deemed almost always unreasonable or an undue hardship. So the first one is a stress-free workplace. We have seen disabled employees, particularly with mental health issues, request and claim a right to a stress-free workplace. And the courts have been pretty consistent, thankfully, to say no. An employer does not have an legal obligation to provide a stress-free workplace, that is not reasonable. The courts have also consistently said that you do not need to hire someone else to do the disabled employee's job. So if the disabled employee is saying, I can't do this, you're going to have to find somebody else to do my job, the courts have said nope, that is not a form of reasonable accommodation. Likewise, if you have an employee requesting an indefinite leave of absence, and by indefinite I mean an employee who says, I need a medical leave of absence and I cannot tell you for how long. I can't give you a projected return to work date. It might be 2 weeks, it might be 2 months, it might be 2 years. The courts have been very clear in saying no. An employer does not need to provide an indefinite leave of absence. Now, if you are an employer that's subject to the FMLA and you have an FMLA eligible employee, at minimum, you're going to have to provide the 12 weeks of FMLA. But if after the 12 weeks of FMLA, the employee and their doctor is saying, we still need an indefinite period of time out of work, the courts have said it is fine to end employment at that time and on that basis. I will caution you that if you're in a position to end somebody's employment due to a request for an indefinite leave of absence, you are going to want very good documentation from the employee and the employee's healthcare provider that is in fact what they are requesting or saying that the employee needs. If an employee is asking for a different supervisor as a form of accommodation because their supervisor is what is exacerbating their mental health condition, the courts have said employers do not need to provide that unless the supervisor is behaving badly, behaving unlawfully, or is actually harassing or otherwise kind of targeting the employee for harassing or discriminatory behavior. Okay, some other examples. New supervisor for depressed employee who claimed supervisor exacerbated her depression. Again, not required unless the supervisor is the bad actor, him or herself. And let me just pause there. We oftentimes have employees claim that their supervisor is quote unquote harassing them or discriminating against them because the supervisor is holding the employee to the company's performance expectations, and that addressing the performance issues is in itself wrongful somehow. That is not the case. While employees can be quick to make that claim and quick to use those words, harassment and discrimination, if you, the employer, investigate that concern and all that you find is that the supervisor is managing the employee's performance in the regular course, as the supervisor would for any of his or her subordinate employees, that is totally acceptable and does not make the supervisor a bad actor. Again, where the current supervisor was the sole supervisor in the department, the courts say no, you don't get a new supervisor. So let's talk a little bit about this interactive process, because if you're ever faced with a failure to reasonably accommodate claim, you, the employer, as part of your defense, really as a key critical part of your defense, are going to have to establish what was the interactive process that you followed and how well did you do it and how well do you have it documented. So, of course, we consider the employee's requested accommodation. If you can meet the requested accommodation, that's great. If you can't meet the requested accommodation, You don't have to grant the employee's requested accommodation if you, the employer, have another idea that is equally as effective. You want to be proactive when you recognize a need. So in a perfect world, the employee will come to you and will say, I'm struggling with a medical or mental health issue, I need help. But that's not always the case, and sometimes it'll be clear as day to the employer that you have an employee whose mental well-being has really deteriorated over weeks or months or years, and it feels like the right thing to do or the needed thing to do to go to the employee and say, we need to talk. The performance or the productivity we need isn't working, and we're worried about your well-being, and we need to figure this out. Both parties are required to have good faith participation in the process. So the employee needs to participate in good faith, as does the employer. And with regard to the employer's participation, this is a really critical component of the documentation process. You want a really good document and a really good timeline of the entire communication process. So if you've met with the employee in person, that should be documented. What was the date of the meeting, who was there, and what was said. If you have an email trail with the employee talking through the interactive process, you should have that documented and kept on file. If you've received doctor's notes, those should be kept on file. If you've ultimately granted an accommodation, I think it's a great idea to confirm that in writing to the employee so that you've got that in file. If you have not granted some accommodations but have granted others, get that documented to the employee. And if you have to make the hard decision to say, nope, I'm sorry, there's no reasonable accommodation here, then you're going to want a really good record of your analysis. How did you result in the decision that no accommodation was possible or that the accommodation requested was an undue hardship? Because again, if faced with a legal claim, that's what you're going to have to establish. Whenever possible, we really recommend that employers work towards a yes. If the employee's takeaway is that my employer cares about me and is working with me towards a yes whenever possible, that is a much better takeaway than an employee whose takeaway is my employer's irritated with me, my employer's being hostile towards me, my employer doesn't have any time or interest in having this conversation with me, and my employer is looking for a way to find a no. With regard to working towards yes, we do recommend, or at least it's a strategy that I've recommended to a lot of clients, and I think they've used it effectively. When you have a requested accommodation and you're not quite sure if it's going to work, you're a little bit worried about it, it may or may not work, it may or may not impact the business to a degree that's unacceptable, consider giving it a try. I would much rather you say to the employee, we're not sure if this is going to work, but we are willing to give it a try. And if we give it a try and if it turns out to work just fine, then great. That will be a win-win for everybody. If we give it a try and it turns out it doesn't work out, two things will happen for the employer. One, you will be able to say to the employee and the powers that be in the event of a claim that you tried, which is better than having not tried at all. And two, you will have been able to gather data during that trial period to establish why it didn't work and why it was unreasonable or an undue hardship. I do think if you're in a position where you're willing to give something a try, but you're a little bit skeptical about how it's going to work, it is important to communicate to the employee that you're willing to give this a try on a trial basis or for a limited period of time subject to review and subject to reanalysis as needed as time goes by. But I think that's an excellent strategy for employers to use, both in terms of defending against claims if needed and trying to find the win-win for everybody. Okay, so let's transition to the FMLA. The FMLA, as we know, is a federal law. It applies to all employers throughout the United States if the employer has 50 or more employees. Okay, so if you have 50 or more employees, you as the employer are subject to the FMLA. In terms of which employees are eligible for the FMLA, employees who have 12 months of employment with your company, whether consecutive or not, have worked at least 1,250 hours in the 12-month period predating their request for leave, and then works at a work site where there are 50 or more employees within a 75-mile radius. So you would be a covered employer, and you would have an eligible employee if all of these are met and they are seeking time away from work on account of their mental illness. They also have to establish, of course, that they have a serious health condition. And serious health condition has it's a long, extensive, multi-pronged definition, but essentially an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. And certainly that continuing treatment by a healthcare provider is fairly easily established by somebody who's struggling with a mental illness. If you have an employee who is seeking time away from work and is FMLA eligible, of course you would send them home or send them the certification of healthcare provider that the U.S. Department of Labor has issued. It's a government-issued document that the employee then takes to their healthcare provider to have completed to establish that they have a serious health condition and how much leave they are seeking. If their healthcare provider establishes they have a serious health condition, they're entitled to up to 12 weeks of unpaid leave. As you know, leave can be taken either in chunks of time, all at once, continuous, intermittent, which means I'm kind of coming and going from the workplace as my medical condition requires, or a reduced schedule, which would be something like, you know, every Tuesday and Thursday off, or I need to leave every day at 3 p.m. or some sort of reduced schedule. The employee is entitled to reinstatement to their position at the end of their FMLA if they're able to come back within the 12-week period. And again, that 12 weeks can end up being a lot longer if they're taking it on an intermittent or reduced work week schedule. They are entitled to take their leave without discrimination or interference. And interestingly and importantly, undue hardship does not apply. So an employer who's FMLA covered and has an FMLA eligible employee does not have the option of saying, nope, sorry, you can't take this leave. It's going to result in an undue hardship to our business. There is no undue hardship concept in the FMLA. It's an absolute right to be absent from work for the stated period of time, regardless of the impact to the business. Okay, I am going to pause there and turn it over to Emily.
All right, thank you very much, Ingrid. I think they're going to give me the power to control the slides now, and I will get going here. My name is Emily Pontius. I am a employment lawyer in the Des Moines office of Frederickson and Byron. So shout out to all of our Iowa attendees today too. Okay, so I'm going to start out with supervisor training. Besides the legal requirements of accommodating disabilities and providing leave, there are many reasons why an employer would want to create a workplace that is supportive of people with mental health concerns. Well-trained supervisors are the single best way to achieve a workplace that is supportive of employees. So what are some of those reasons? Well, Ingrid touched on some of these. One, just to have a more productive workplace to reach all those business goals that you've probably made for the new year, to retain employees regardless of mental health status, and also your reputation with your clients, your customers, your shareholders, your board of directors, and of course the community. It looks like, okay, I tried to advance the slide and it didn't work, so can someone do that for me? Try one more time.
Okay, try clicking on your screen and then advance.
Okay. There we go. Okay, thank you. Sorry about the delay there. So the EEOC created a task force to study harassment in the workplace a few years ago. One of the witnesses who appeared before the task force made the statement that appears on the slide before you. And my favorite part of this is, quote, "We teach them empirically sound things to do and say." Now, if you know the basic rules about what to do as a supervisor, but you've never practiced what to say when an employee appears before you, chances are that you're not going to say the perfect thing. When I get someone ready for a deposition, we practice for the tough questions. We practice the best way to convey the truth. And when an employee approaches a manager and says, "I have a problem" or "I need help," it is the same thing. And the manager needs to know exactly what to do and say. And I think the stakes are pretty high in a situation like this. You have an employee who has summoned up courage to speak to their manager about an issue that they're having. And really within the first few seconds, they're going to look at their manager's face and determine, is this person going to be working with me or against me as I struggle with this issue? So we do training, because managers and supervisors are in a unique position to notice the signs and the symptoms of distress and to create an environment where it is safe for employees to seek the help they may need and that employers may be legally required to provide. And what's important to know here is that these interventions can help. The resources that you can provide as an employer make a real difference. 65 to 80% of people who suffer from an emotional disorder or a mental illness will get better with proper treatment. And that is a success rate that exceeds the recovery rate for many non-psychiatric illnesses. I think as employers and admittedly as employment lawyers, sometimes if we see someone who's struggling, we tend to attribute their struggle to their personality. And it is a disability or a serious health condition just like any other. And people can recover and go back to being a very productive employee in the workplace. Now, on the other extreme, it is important that well-meaning supervisors not go too far. It is not a supervisor's job to guess at what illness an employee might have. And certainly supervisors need to be trained that mental illness, mental disorders are not a joking manner. It's not, you don't have to go too far to find somebody in a workplace who's making a joke about somebody having OCD or obsessive compulsive disorder. What they really mean is this person's very detail oriented. It's difficult to scrub your workplace of all comments like that, but it is important to at least train your supervisors to not participate in that kind of discussion. So what are the signs of distress in the workplace that you and others and your supervisors should be looking for? Well, displays of anger or blaming others, especially if this is uncharacteristic. Some people are just angry even if they're not suffering from a mental illness and blame others no matter what. Those are a different presentation and a different topic. But if someone is behaving in a way that is uncharacteristic of the way they normally are in the workplace. Lack of concern for safety. This is more obvious in an industrial environment. But certainly you can see it in an office environment as well. Frequent absenteeism and tardiness, frequent statements about being tired. Decreased productivity could be inability to concentrate or distractions from family and personal issues. That can also be part of what happens when somebody is suffering from mental illness. And of course, a change in attitude about work, about the regular challenges that are faced in the workplace, and a change in attitude toward team members. Additional signs of distress would be difficulty concentrating, making decisions that normally would have been easily disposed of, or difficulty remembering things. An employee may have unexplained aches and pains, a reduced ability to work with others. You may find that they've withdrawn from social events that they otherwise would have been happy to participate in. And of course, signs of alcohol or drug abuse. If somebody is drinking more or appears to be hungover at work, though not under the influence, things like that, that may be a sign that someone is suffering from mental illness and is attempting to self-medicate in that way. So what can supervisors do? It's important to train supervisors as to what is safe to do. What is safe to say to an employee who you see struggling? It is fine to show concern. It is fine to say, you seem tired. Are you having trouble concentrating today? You seem stressed out. I'm worried about you. We missed you at the latest social event. Is everything okay? And to ask if they can help. Now, again, we're not asking supervisors to diagnose an employee. We're not saying you seem distressed. Are you suffering from diagnosable anxiety? Do you have PTSD? These are not things that you want supervisors to say to an employee, but it's fine to say things to open the door and be supportive. This is safe to do. It's also okay to talk about resources. To say, if you or anyone ever needs it, we have this resource available in our workplace. Or these are just some examples that I have here. I know several employees have used our EAP when they've gone through a divorce, when they've gone through struggles with depression. And EAP programs, resources like that are not just for the employee when they're going through a tough time, but also through sometimes, depending on your benefits, can be for the family members of employees, or to help your employee go through the experience of helping a family member who is struggling with mental illness. Now, the single most important message, I think, for someone who is transitioning from being a peer to a supervisor in the workplace is that they develop and maintain a reputation for confidentiality and discretion. I think that that transition can be so difficult because the person with whom they used to confide and there was no supervisory relationship is now someone that they must supervise and that they need to be concerned about on a different level. Employees have to know that their supervisor is not going to gossip or share information inappropriately, and also that they're not going to promise confidentiality when they actually need to report up the chain, potentially to do an investigation or to initiate a disciplinary process. So definitely training supervisors and making sure they understand the gravitas of their role when they become a supervisor is important in many ways, but also in the case of having an employee who may be suffering with mental illness or needs to take advantage of an ADA accommodation or take some FMLA leave, because they're not going to reach out to their supervisor if they know that their supervisor is going to share that information in a way that they should not. Supervisors, aside from providing the support that they need and identifying issues, they also need to address any performance and conduct issues as they would with any other employee. It's very important that these things be separated. And when I'm talking to an employer and trying to advise them on how to handle an employee situation, and they bring up, well, and I also think that they took some leave recently for depression. I say, you know what? These are two different roads. We have the road we're going down here to deal with the intermittent FMLA issue or the accommodation issue, but then separately, we have this issue of performance or conduct in the workplace. So let's just draw a very bright line between the two. It's fine to go down those two roads at the same time, but they don't intersect, which of course is not reality, but it's how we have to handle things to make sure that we're complying with the law. So if you're training supervisors or you yourself are handling employee issues like this, the key is to focus on the performance issue or the conduct issue, not the disability. Provide concrete examples of what performance issue and what the conduct is and how it's impacting the workplace, how it's impacting the client, how it's impacting colleagues. Employee, you are doing X, and this is the impact it has here that is negative. Stating concrete expectations and what the consequences are when those expectations are not met. And then offering support for compliance. And that takes the form of asking, do you need anything from me? Do you need anything from the employer to meet these expectations? Now, it's quite likely that that does lead to intersecting with that other road of the illness, and that's okay. This may lead to another request for an accommodation. It may lead to a request for leave or time off. And if that is what that employee is entitled to because of their serious health condition or disability, that's okay. So there's certainly barriers to all of this happening in the perfect way that we'd like it to. Some people are very hesitant to bring up or encourage talking about quote unquote personal issues at work. They may believe it's unprofessional or it's invasive, it's too much information. And I would really argue that as a manager or as a human resources professional, it's your job to support employees to encourage a productive workplace. The risk of not bringing up these issues is greater than the risk of having the conversation. The challenge is just to figure out how to raise the issues in a professional way that does not invade someone's privacy or make someone share more than they would like to. And you do want to draw that line depending on how large your company is. It may be that when someone brings up a medical issue, they go work that out with someone in a different office, and you as a manager or your area of HR, you just become privy to what you need to know, and that's fine. But we do want to have an environment where employees feel welcome to bring up the issue initially. So a survey in 2018, I don't think that's out of date yet, even though we're knocking on 2020 now. A survey in 2018 found that 72% of employees want employers to promote mental health and well-being. And this was rated as more important than equality, more important than sustainability, and more important than diversity, which those things are all really important. So I'm not saying that we should put less emphasis on those things, but they don't see it as fluff, I guess, is the important thing to take away from this. And this was true across generations. So the survey included people in generations Z and X, it included millennials, and it included baby boomers, and all think that they want their employers to promote mental health and well-being, even more than they want to get rid of plastic water bottles, apparently. So something to keep in mind. Now, certainly employees themselves may be unwilling to admit that they need help. They fear adverse action in the workplace if they admit to having a mental health issue, and they fear judgment. There's still very much a stigma about mental illness, so I think that is starting to fall away. And they may have a lack of trust. So once again, going back to the need for supervisors to make it known to their employees and sort of walk the walk in terms of maintaining confidentiality and not talking about employees' issues in the workplace other than when they need to. We all want to reduce the characteristics of the workplace that may exacerbate mental illness. So here are three. These are risk factors that were identified by the World Health Organization as workplace risks to mental health. Inadequate health and safety policies. You may think that if you work in an office environment, if you don't have you're not in a factory, you don't have heavy equipment, that this may not be part of what you need to do to assist in promoting mental health. But a few things that you might want to consider. Could you reduce the importance of alcohol at workplace events? That's especially something to consider as the holiday parties are coming up. Consider whether there is a culture of pulling all-nighters when there is a big project. Is there a way that you could reduce the negative health impact of periods when the workload is heavy? For example, could you hire contractors to do the ongoing tasks during a big project, cater healthy meals, provide assistance in finding care for children or other family members, or even just provide some time off when the project is over? Secondly, poor communication and management practices are a risk factor. Consider how effective your performance evaluation and goal setting processes are. Most managers are not good at providing honest feedback that is calculated to improve performance. This can be improved through supervisor training. I keep saying that. I do to some extent believe it's a panacea for almost all problems in the workplace. So supervisor training is very important. And many times I see employees who were discharged for performance, but yet you look back at their performance evaluations and it says they met expectations. We avoid issues so that we can get through the day, and then we create a bigger problem down the line. If supervisors are trained to provide good feedback and help employees improve, we can avoid the performance problems or ongoing performance problems and potentially avoid the need to terminate the employee at the end. It takes time, certainly, but so does recruitment, so does hiring, so does training. Turnover is very expensive for most employers. And then another risk factor is limited participation in decision-making or low control over one's area of work. It's important to engage employees in decision-making so that they have a sense of control in their workplace. And this could mean involving more employees in high-level meetings, initiating career development programs early on in an employee's tenure, making sure supervisors recognize and reward employee contributions. It could mean asking workers to help decide what nonprofits the company will support during the holidays. There are so many ways, and I know that most people who are in-house counsel dealing with HR issues or human resources professionals, you don't often have the luxury to sit back and think about how you could improve on these issues. I know that that is a luxury that many of you don't have, but it can make a difference in getting people engaged in the workplace and limiting the risk factors in the workplace. And just to kind of underline this, it's a quote from a person at Manpower. One of the best ways to create a culture that supports mental health is to ensure people experience their jobs in a meaningful and purposeful way. Mentions autonomy, giving them the resources they need, providing support, as well as giving them independence, which can reduce the risk of mental health issues in the workplace. So additional risk factors here would be low levels of support for employees and flexible working hours, unclear tasks or organizational objectives. Again, according to the World Health Organization, these risk factors create a negative working environment that may lead to physical and mental health problems, harmful use of substances, absenteeism, and lost productivity. The World Health Organization estimates that depression and anxiety cost the global economy approximately $1 trillion each year in lost productivity. So in other words, the environment at your workplace may be causing the mental health problems that make your business less productive. And certainly that is not the kind of synergy that we're looking to create in the workplace. Another useful statement here from Tomas Chamorro-Pamuzik at Manpower Group. Important that managers do not check out from their employees. There are good supervisors in the world, and there are supervisors that have a lot of room for improvement. And I think that in some cases, supervisors with room for improvement say, I'm really a hands-off supervisor. I try to hire the right people, and then I trust them to do their jobs. Well, that's certainly a supervisory strategy in some cases, but it can also, there's also a lot of supervisors who say that when what they really mean is, I'm going to check out and just hope that things work out because I don't think I'm a good supervisor. According to this person from Manpower Group, the worst and most stressful leaders are those who are absent. They leave their employees without direction or feedback and show little concern and consideration for their staff. That's not good for morale, it's not good for employee well-being, and it's not great for your productivity as a business either. So how do we reduce the risk? foster an emotionally safe environment. And I am not, I'm not advocating for a nap room or a place where you can throw axes or, you know, anything like that. But here's a few ideas. Do you have potentially affinity groups for caregivers? Are supervisors alert to bullying and gossip and conflict? Are they in a position where they will intervene? Will they identify and remove the person who is the problem? You know, we all have people at work who single-handedly are exacerbating the mental health condition of employees and are causing turnover. And it takes a brave supervisor and a brave employer to deal with those individuals. You also want to create awareness of the programs you have. For example, your EAP programs, insurance benefits that may cover mental health counseling, for example. And also encourage employees to reach out for help, to connect with and support one another. Be open about the corporate support that you may be providing to local and national mental health initiatives and organizations, like, for example, the National Association for Mental Illness, NAMI. Here in Des Moines, we have the Des Moines Pastoral Counseling Center. So many resources, and many of you work for companies who are very generous in your support. Let your employees know about that this is an issue that you're aware of and are supportive of improving. Bring in an outside speaker for your next all-employee meeting who may even be brave enough to talk about a personal mental health journey or resources available through the employer or in the community. So strategies to reduce risk continued here. I think being clear about job expectations is key. If someone is suffering with a mental health issue, as an employer, you don't want to make it worse by requiring them to guess what your expectations are. Be clear and be direct. Offer support as necessary, perhaps in the form of an accommodation, and make sure to document any action you take due to performance. That documentation needs to not reference medical leave or accommodations or opinions regarding the employee's condition or recovery, but just to document the performance issue and the discussions that have taken place about that. So to wrap up, there are a couple, I guess 3 cases that I think are actually very positive news for employers. The first one, the employee had frequent and sporadic absences for mental illness, and the employer just asked for some notice of when he was going to be absent, and he brought a lawsuit. Bowden was terminated. He brought a lawsuit against his employer for multiple claims, including discrimination for failing to accommodate his disabilities, and the court determined that the employer's request was fine. It was fine to ask that there be a routine in scheduling the absences. This was not a failure to accommodate, and the plaintiff did not show that his appointments could not be scheduled in advance. The second case I just want to briefly touch on, an employee with PTSD requested a peaceful, calm environment, and the court determined that was not really a request for accommodation because that request was too vague. In this particular case, it was at a bank. There were no non-branch jobs available, and the bank was not required to eliminate an essential function of the job, such as public interaction, in order to accommodate. And the very last case that I want to touch on is the Jenkins versus MedLabs case. Jenkins left work without notice to complain about mistreatment by other employees, and the employer assigned all of the employees involved to EAP counseling, which Jenkins refused, and Jenkins alleged discrimination. The employer here was unaware that he had been diagnosed with an anxiety condition and suffered from depression. And of course, discrimination claims can't be based on impairments that an employer knows nothing about. The EAP counseling employer wanted her to attend was actually dispute resolution counseling. So this was not a matter of the employer perceiving a disability. There was no mental health counseling at all, and the 2 other employees were also required to attend. So the good news is that the employer got summary judgment. For these reasons, the reason that the EAP was for dispute resolution, it was required for coworkers, This is key here. Asking someone to get EAP counseling is not adverse action. And the employee's refusal to do the training, or excuse me, to do the EAP counseling was a legitimate and non-discriminatory reason for the discharge. And it is 1 o'clock, but I believe we can still answer some questions.
Absolutely. Emily, can you hear me?
I can.
Okay, great. So I have 4 questions here. I'll take the first 2, and then Emily, I'll read the second 2 to you.
Okay.
So the first one, your statistic of 1/3 of EEOC charges in 2018 alleging disability discrimination, were all of those with regard to mental health, or does that include all disabilities? That statistic is all disabilities. So I don't believe the EEOC publishes data dividing physical from mental disabilities. So that statistic was all forms of disabilities, both mental and physical. The second question, and a great question, I'm glad you raised it. What about employers that have less than 50 employees? So if you have less than 50 employees, you're not subject to the FMLA and the leave obligations under the FMLA, but you are subject to the ADA, the Americans with Disabilities Act, and your state anti-discrimination law, depending on what state you're in. So in Minnesota, you'd be subject to the Minnesota Human Rights Act, for example. And both the ADA and those state laws require reasonable accommodation, and a very common form of reasonable accommodation is a leave of absence. And so employers with less than 50 employees are going to be obligated to provide leaves of absence on a full-time, intermittent, or reduced schedule basis as a form of reasonable accommodation in many cases. I will also say, if you are a covered employer, you've got under the FMLA, you have 50 or more employees, but you have an employee who is not yet eligible for FMLA coverage. Maybe they've been with you for less than a year, or maybe they've exhausted their 12 weeks of FMLA. You still have to think about and worry about the ADA. So if you have an employee that's been with you for less than a year and is seeking medical leave, you need to think through that and probably grant that under the ADA. And if you have an employee that's taken and exhausted their 12 weeks of FMLA and they still need more time out, you need to consider any request for additional leave under the ADA. Is it a form of reasonable accommodation, or do you feel like you're in a place where you can safely say, no, we don't or are not going to grant additional leave beyond the FMLA? And those are really, those are tough cases, tough analysis, and a lot of it will depend on tolerance for risk. Okay, so Emily, first question to you, and I think it's a tough one. I don't have a great answer other than maybe trade associations. The question is, I'm curious about more resources for managers and supervisors to get training. That seems like a huge piece. Also, are there resources for managers to get support themselves when supporting employees with diagnosed mental illnesses? It can be very frustrating.
Sure. Thanks, and thanks, Ingrid, for signaling that you're not going to help me out on this one. That is a tough question. I mean, as far as the resources for managers and supervisors to get training, you know, that is certainly something that, you know, the law firm you work with, maybe one that provides training to supervisors. That's something that I do for employers, is do supervisor training. I think that, you know, in terms of how in-depth you want to get, I'm aware of organizations that would be happy to raise awareness among your employees. I think one of the key things is just to think, okay, are there accommodations for the issue that you're talking about? There is an online resource called Ask Jan, the Job Accommodation Network. And that's a great resource for kind of individual questions. I think probably NAMI is an organization that could direct you to resources to learn more about it. I would also recommend for you to take a look at the America's Job Honor Awards. which was an organization that assists employers and also recognizes employers who give employees a second chance, essentially, by providing employment to people who have, for example, been incarcerated or who have suffered from mental illness. I think, there may be some of you may participate on different, networks through your state or local or even national SHRM organizations that may provide that as well. And then I can see, Ingrid, the second question here, so I'll go ahead with that. And the question is, what if the employee who is creating havoc among employees is the one with a mental health diagnosis? Yeah, that's very difficult. And I think what you have there is you have someone with a mental health diagnosis, so you're going down that one road, but what you're identifying here, if they're creating havoc, if they are conducting themselves in the workplace or having performance issues in the workplace that are creating problems and disruption, that is a performance issue, and you would follow your regular procedures, whether you meet and put in place a performance improvement plan with regard to the conduct itself, and then hold the person to the expectations that you have. And at the same time, you're traveling on that parallel road in terms of providing accommodations, in terms of providing leave, and providing support. So it's important that the, one thing I noticed in that question is creating havoc. And that would be perfectly fine for a question in this forum because we all know what you're talking about. But when you are talking to that employee, we want to get it down to actual concrete behaviors. What do we mean by that? And what is the person doing? What needs to change? What improvements do you need to see? Ingrid, do you have anything to add on that?
I don't, no. That is great. And those were the 4 questions we had come in. So certainly I want to thank everybody for participating today. If you have follow-up questions or if we can support you as you deal with these issues as they arise in your workplace, both Emily and myself and our colleagues here at Frederickson and Byron would be very happy to do so. We are going to sign off. Again, thank you and happy holidays to all of you. Thank you.